Welcome to Creating a Criminal History Evaluation Tool for Employment Purposes. Mike Coffey, President of Imperative Information Group. We're going to look at the reasons you probably as an employer want to have a tool and a policy in place before you ever meet your first applicant in regard to how you're going to use criminal history, whether they haven't told you about it or you received it from the background check. And we'll go through a number of those policy considerations that you may want to think through. And then I'll share some tools that we've developed with clients over the years that make putting some of that together a little easier. Real quick, a little bit about me. I'm an HR guy. I've been in and around HR my whole career. And for the last 17 years almost, I operated an HR consulting practice and background training firm called Predictive Information Group. I have had the privilege of consulting with a lot of our clients all over the country over the last 15, 16 years, and have a lot of what you're going to hear today is stuff that basically we either developed together or I just stole from them. But I work with a lot of smart HR people, and I work with a lot of their attorneys and legal counsel. So you're going to hear today some of the things that we've put together to help clients make sure that they're doing what they ought to do. There will be a certain amount of what, for better lack of a better term, we call the gospel according to Coffey, which is basically ideas for being practical but still compliant and meeting the expectations primarily today. We're talking about the EEOC, but maybe also some of the local and state laws that are soon cropping up how employers use criminal history information. But there's a couple things I wanted you to know is that I'm not a lawyer, and I'm especially not your lawyer. And whatever you do, whatever you come away with today, before you implement it, take it back to your lawyers, your own legal counsel. There may be reasons that you guys do things in your organization differently and would maybe make sense for some of our other clients. And so we want to make sure that you, it says, I'm getting notes here that there's a lot of problems. I think it must be a problem with the GoToMeeting. Sounds cutting out because I'm not getting any feedback here. Let's something. Is there still a lot of sound cutting out when you hear? Somebody drop down and let me know. So this is the problem not with us, but it sounds like with GoToMeeting. Go try something else. I'm going to put on a wireless headset and connect electronically. Bear with me. Everything was, we tested all the sound out earlier. Okay. Now tell me how it sounds. How does that sound? Better. Okay. Well, we just had a bad telephone connection with the GoToMeeting people. Okay. Well, you missed a whole bunch. Tell you what, Welcome to Creating a Criminal History Evaluation Tool for Employment Purposes. I'm Mike Coffey, President of Imperative Information Group. Today we're going to talk about the issues surrounding the use of criminal history and the ways that the EEOC wants you to look at criminal history and some different state and local laws as well, but also ways that you can be practical in approaching those and still hire a safe and effective workforce. A little bit about me quickly. I'm an HR guy. I've been in and around HR my whole career. I've been blessed to work with a lot of really smart clients over the last almost 20 years. And some of what you hear today will be stuff that we put together
working with clients to help them solve their problems. And some of it I've just, quite honestly stolen from some really smart clients who've been gracious enough to share with us. A couple things to make sure you know: there will be a certain amount of the gospel according to Coffey today. And again, that's kind of an approach where I try to be practical in compliance so that you can still hire a safe and effective workforce. You still make informed hiring decisions, but we still want to tip our hats to the expectations of the EEOC and other entities, even where we think they're kind of unreasonable, because you don't want to go through the headaches and the hassles of a bad employment decision. I'm getting a lot more of these notices saying that you can't understand me again. And so it's strictly a go-to-meeting problem. Yeah, okay, so it's definitely a go-to-meeting problem. Everybody's sending me notes here telling me it's still cutting out. That's very frustrating, but we've done it now both over telephone line and over the headset going straight to the go-to-meeting electronically. So that's frustrating. I tell you what. Okay, well, so somebody just told me, and I hate to ask you to do this, that they hung up and dialed back in, and the sound works better. Thank you for telling us that, Tina. So if you are having audio problems, what I would probably suggest is disconnect and reconnect and see what happens. Also, I will send everybody the notes, and at the end of the webinar, everybody who signed up for the webinar will get a copy of all the notes and slides and all of that information. I can see people dropping off, and hopefully you'll come back. I'm sorry about this. This is technology hell. Okay, so let's just continue. So I do want to reiterate, though, that I'm not a lawyer, and I'm especially not your lawyer. So I want you to take whatever you hear today back to your legal counsel before you make any decisions. This stuff, there may be reasons you're doing what you do, even if it is different than what we're advocating. And so you need to talk to your legal counsel for that, because even at the local city level and municipal level, there are things on employers about how they use criminal history. And we're constantly trying to adapt this presentation and our tools that we use in consulting to help employers get where they need to be and still be compliant. But if any of you folks are in New York City, for instance, or you have operations in New York City, you've got a unique situation there. And so you want to talk to your legal counsel before you make any changes to your process, because there may be reasons for doing something differently. So let's start off here with a poll real quick and see if we can get that to work. Okay. Do you have a policy covering the use of criminal history information in your organization? And that's not your background check policy, just a policy on criminal history information, whether the applicant gave it to you or you came back on the background check. Okay. Half of you have voted now. Okay. A few more people jump in there and give me a vote. And we're at about 60%. Okay. Okay, let me close that and share the results. As you can see, about half of you said you did have some sort of policy that shared the, that covers your use of criminal history. And then another quarter of you just flat said no, and a quarter of you said, sort of. And that's usually where most employers are, kind of, sort of. We've got a policy, maybe it's not as documented as they like. It's a cheat sheet in their lap drawer or something like that. And the problem with that, of course, is the difficulty in getting your hiring managers and folks like that to comply with it. Plus, makes it difficult to ever defend a claim or even an investigation by the EEOC or somebody like that. So I would suggest you probably want to have a little better process in place. Yeah. Okay, so let's jump into why employers use criminal history. Real briefly, it seems obvious, but it gets lost in a lot of the discussions, especially with the discussions we've had in the recently about the ban the box movement and things like that. Certain groups like the National Employment Law Project and others would have you think that there's this horde of employers out there refusing to hire anybody with any criminal history for any reason. And obviously that's not the case. I talk to employers all the time, all over the country, and I rarely ever come across an employer, and when I do, it's a very tiny, small employer who refuses to hire anyone at all with any criminal history. But there are reasons we care about criminal history, right? I mean, we've got assets in our organization. The company owns property, merchandise, things like that we need to protect. More importantly, we have employees that we need to protect, and we have the public who we interface with. We've got to protect them. And so certain people with certain kinds of criminal history may not be fit for certain jobs, and we'll talk about some of those considerations in a little bit. But the ultimate thing is trust. Whenever something's gone wrong in an organization, it affects the trust of your employees, and it also affects your company's reputation and the trust the community places in you. And so there are a lot of reasons to know who we're hiring. Sometimes we use criminal history strictly to exclude an applicant, right? So we've got someone who, here on the left he's bombing his DWI test, it looks like. And then on the right, you can see, this guy on the left is probably not the guy you want driving the forklift in your munitions factory. So those kind of issues are, that's pretty clear. If somebody's got a DWI, I really don't want them driving a forklift in my warehouse if it's a recent DWI, or certainly operating a motor vehicle, or even we work with a number of golf courses, and they're concerned about the safety of the people operating those large mowers and even golf carts sometimes. They want to make sure that these people are safe, so they use driving records, driving history as one thing that they examine. So sometimes we just exclude people strictly because of the criminal history makes them ineligible for certain kinds of position. But often we also use it to evaluate candidates. So we look at two different candidates, and two candidates being pretty similarly situated, but one of them has some sort of criminal history and the other one doesn't. Sometimes that factors in to evaluating what kind of employee they're going to be, what kind of judgment have they shown in the past, how compliant have they been in the past, are they going to be more to manage? Here's what an example of that looks like. This is Dick. Dick has 9 years of relevant experience for the position and an MBA and neutral job references, and he performed well during the I'm looking here, I'm still getting, some people say they're still only getting garbled words. I'm sorry about that. I don't know how we're going to fix that. I'm going to go on for those who can hear me, and hopefully we can get the rest of you the information. So anyway, you see all this, and Dick has no criminal record. Then we've got Tom. And Tom has 9 years of relevant experience, an MBA, neutral job references. He performed well during the interview. But in 2013, he had a theft by check. In 2011, he had an open container violation. In 2009, he had a failure to appear on a, so let's say a traffic ticket or something like that, where he just didn't show up in the court like he was supposed to. And so if I'm evaluating these two candidates, who looks like they're going to be easier to manage? Quite honestly, I think most of us would agree that even if this theft by check, open container violations, FTA, those aren't really, for a lot of positions, aren't really directly relevant. But isn't it reasonable to evaluate candidate A and candidate B against one another and include this information in the evaluation, just like we would include whether they've been terminated from a previous employer? Something like that. Something, and that's probably less severe than some of these offenses. So those are the kind of things that employers also do to evaluate two different candidates. And that's a meaningful evaluation that gets lost in a lot of the conversations around how employers use criminal history. I just got a note A couple people said that listening through the computer speakers or hanging up and reconnecting both seemed to fix the audio problems they were having. So I'll just share that if you want to reconnect. So let's jump into Title VII of the Civil Rights Act. This is the law that has the most impact right now on employers' use of criminal history, although now we're getting into areas, especially like New York, New York's Article 23A and New York City's Fair Chance Ordinance about how employers can use criminal history. That's getting even stickier. And I'm afraid where we're headed is, while Title VII applies nationwide, we're headed toward a situation where we have some even municipality by municipality, city by city type ordinances as well that we have to worry about increasingly. But let's jump into the Civil Rights Act. It was passed in 1964, and Title VII of the Civil Rights Act creates the race, color, sex, national origin, and religion protected classes. And of course, there's other protected classes as well now. Americans with Disabilities Act, the Age Discrimination and Employment Act, those other laws, GINA, those all create other protected classes. But primarily today, we're talking about race, color, and national origin protections. The last time Title VII was modified with relation to what we're talking about today was in 1991 when the first President Bush implemented or signed into law changes regarding disparate impact under the law. And so there are two kinds of discrimination in Title VII. First, there's disparate treatment, and we know that when we get it, right? You know, we're not going to hire women for this job, or we're not going to hire, you know, African Americans for this job, or anybody with an accent can't work in our call center. Those kinds of things. That's disparate treatment. We see that. We know that when we see it. But there's also a kind of discrimination called disparate impact. And that all comes out of the 1971 Griggs versus Duke Power case that was the first Supreme Court case to recognize this idea of disparate impact. And basically what it is when you've got a policy in place that on its face doesn't seem to address age, race, sex, national origin, any of those, color, any of those things, but in its implementation it has a disparate effect, a disparate impact on people in that category. And in the Griggs case, it was about education, and you had a high school diploma and passed an IQ test to become a manager. And because Duke Power is in the South, and this was the 60s, African Americans had lower opportunity to get an education than the white population. And so just in and of itself, having the requirement for a high school diploma was having a disparate impact on those candidates. And they were able to demonstrate, and this is important, they were able to demonstrate that people with, that there were people, white managers who were managers before they ever had that policy in place, who didn't have a high school diploma, but were able to successfully perform the jobs of a manager. So there were, you know, having a high school diploma didn't predict success in the job necessarily, and it was creating a disparate impact, so it made it illegal discrimination. And then in 1975, we had a case called Green versus Missouri Pacific. This is a federal court case as well. Missouri Pacific Railroad, MOPAC, had a policy in place that said we don't hire anybody with any criminal history, period. So it was just a blanket exclusion. And Mr. Green was had served time in federal prison for draft evasion during the Vietnam War. He was out of prison, had been out of prison, I think, about a year and a half. And he applied to work at Missouri Pacific. Missouri Pacific said, no, sorry, we can't hire you. Mr. Green, who was African American, by the way, sued. And the federal court agreed with him because his argument was African Americans are arrested, prosecuted, and convicted at a higher rate than the white population. And because of that, any blanket exclusion like this is going to adversely impact African Americans. And without considering the offense, the nature of the offense, and the age of it, the the federal court agreed, you know what, in and on itself, your policies don't have a business necessity, and a strong business necessity, and they're too broad. So we're going to agree with the plaintiff here that you're creating an illegal disparate impact. And you should probably, as an employer, look at things like the nature of the offense. What did they actually do? How long ago was it? And how does it relate to the job? Now, you hear these three things said, quoted as gospel, that these are the three things you have to consider. But that's not what the court case said, and that's not what the law says. The court case just said these are things an employer may consider. It didn't say employers going forward must consider this, but you hear it said that way. These are called the green factors, and they always make sense, but there may be other factors that you want to include in there additional that are job relevant as well. So the bottom line on that is just review the total applicant. Look at everything the applicant brings to you. Don't exclude people just because they've got a criminal history, and I know you're not, especially with unemployment at 4 or 5%. You're not just willy-nilly excluding people from employment because you've got to fill these seats. In fact, I spend more time talking to my clients who call me and say, hey, I'm thinking about hiring this guy. Am I crazy because of his history? And often I can walk through and talk to them about different things that they might do, controls that they might put in place. If it's a drug offense, it's somewhat recent and they're concerned about it, set the guy up for regular drug testing that, that unscheduled, unannounced drug testing, things like that. There's things you can do in certain kinds of offense that you can probably put somebody in a position. Now, it doesn't mean you're required to, but when there's a business necessity to get that job filled, it may make sense for you to do that. But you want to look at the whole employer, the whole applicant, and get an idea of what they bring to the job, and does it make sense for us, in this case, to go the extra mile on behalf of the applicant and the company and put in some extra efforts to make sure that we're safe, that we're not creating an undue risk, but at the same time we want to make sure that we make an informed hiring decision. So what you definitely don't want to do is something like this. Just clean background check required, no felonies allowed. Even a felony, even a segmenting just according to felonies can be problematic. When you're telling an applicant no felonies are allowed, in Texas your third DWI is a felony. If somebody got their third DWI 15 years ago, should that really eliminate them from most jobs in your organization? They're a felon, yeah, but is that really something that should prevent them from driving a desk in your organization? I mean, that doesn't mean they can't be a good accountant or any computer programmer or whatever. There's a whole bunch of things that you can do that would be that have, just because you're a felon, you wouldn't be eliminated from. And no convictions for theft or dishonesty. It's a similar kind of situation. What would you do, if you've got this as your policy? And I see this from time to time, especially in like Craigslist job postings and things that are being posted by pretty unsophisticated employers. But somebody convicted of shoplifting 20 years ago at the age of 18, is that really a conviction that should keep somebody from employment? Even if you're not talking about getting sued about it, even if you're not concerned about the EEOC concerns, does it just make sense as an employer to eliminate qualified candidates who otherwise would be great to do the job over something that's not really job relevant and is probably not reflective in and of itself of who the applicant is today? So just to make sure you're not shrinking your talent pool, you want to make sure you're not overly broad here as well. In 2012, the EEOC came out with a new enforcement guidance, and it's a long document. We have a whole webinar just on EEOC and Title VII issues. I've probably spent more time, given our technical issues today, than I wanted to on dealing with Title VII, but at least I want you to know it's out there. And it's a pretty good document as far as relating the history of disparate impact law and issues around using criminal history. Problem is they just draw some kind of crazy conclusions about what employers should do. But you need to understand that this enforcement guidance is primarily used by their own investigators. And so when they come in and investigate you, if an applicant complains that that you created a disparate impact against African Americans or Hispanics because of your use of criminal history, they're going to use this document as how they evaluate whether they're going to try and take action against you or not. So you really need to be familiar with it. Like I said, we've got a whole webinar. It's recorded on our website. You can go look at it, but and download the notes and everything else. But you want to, they go through the green factors, the age of the offense, its relationship to the job, and the age, nature, and the nature of the offense. So the age, the nature, and the relationship to the job. They go through each of those pretty good. They do a pretty interesting job there. But then they add this thing called individualized assessment. And again, we go through this pretty deeply in the other webinar, but the idea is that you should give the applicant an opportunity to explain why your policy should not apply to them. So what else, if your policy just deals with strictly criminal history, what else in your policy, or what other opportunity are you giving the applicant to explain how that criminal history from 3 years ago or 5 years ago or 10 years ago is not reflective of who they are today. That's not in Title VII anywhere. There's no court cases out there that say that, but the EOC believes you should do it. And because they want you to do it, I would suggest that you find a way to do it. And we've, again, in that webinar, talked about some different ways of addressing that without bogging down your process. But the whole thing we need to remember here is that if we're going to create a really good screening process, it needs to focus on the predictive value of that past behavior towards future behavior. What they did in the past, how does that tell us about what kind of employee they would be there in the future? Now, there are, again, some states that require a close relationship. That past criminal history has to tie directly to the job. So if it was a sexual assault case, clearly we're not going to put them into work with children. That's a direct relationship. But I would argue that a sexual assault case, makes somebody unfit for a lot of different jobs because it just what it tells you about their judgment, their character, depending on how long ago it was and all that. And so you need to know, again, what the specifics are in each state that you're working in, or even at the city level now. So let's run a quick poll here. When do you inquire about your applicant's criminal history? While you're doing that, most of you have stuck with me. I really do appreciate it. I hope you've worked out the sound issues on your end, but and we record all these webinars, so it's going to be really weird to have all these weird conversations on the recording, but we'll put it out there. So let me close this and share the results. And as you can see, about a little under half of you asked on the employment application, and I would bet 3 years ago, 4 years ago, probably 75% of you were asking on the employment application. 16% of you are asking after the interview, and almost a third of you are asking after the offer, which that's a number that's really increasing. So we've got a whole webinar just on criminal history inquiries, and it's recorded out on our website. I just delivered it a couple weeks ago, so it's pretty fresh. But again, this is an area where the ban the box movement is becoming significant for employers because they are putting limitations on when employers can inquire about criminal history. I wish I had time to get into that one because it's a hot issue with me, because I think accusing employers of being unfair and putting all these restrictions on them isn't smart, and it's unfair to paint employers in that light. Plus, ban the box, it's not going to help anybody get a job anyway. If you've got a policy that says we don't hire people with this criminal offense in this time period for this particular job, or this is real high risk, doesn't matter when you find out. You're just going to waste all your time doing interviews and doing all of that, and then you turn around and have to eliminate your candidate at that point. The problem is what's it going to look like in front of a jury? So now you've eliminated somebody because of their criminal history, because of the risk specific to that job. I mean, if they sue you and say that you're treating them unfairly because of their criminal history, because what we're really doing is creating a new protected class of called criminal offenders. But if they sue you, you're going to have to defend now that, yeah, they were qualified, except we didn't have all the information. And when we found out with their criminal history and, you know, their past poor judgment, we made a different decision. So that's a hard thing for employers, and we're going to see how it plays out for employers. But I think it's going to be really challenging, especially for employers in places like New York. So we're going to jump into a little of the gospel according to Coffey here as well, because I want to make sure that you get into what we call a bulletproof screening process. What does it really mean to have a policy, a product, you know, a whole process in place that lets you comply with the law, meet all those requirements, and not even be in the gray area, but at the same time hire really a safe and effective workforce. And what it really boils down to is planning in advance. If more employers had good policies and procedures in place, they would be they'd be in a lot better shape when they're challenged for their selection decisions. So we really believe that a good screening process, a bulletproof screening process, starts with the job description, doing a risk assessment, just looking at the job description, working with that hiring manager to identify what the real risks associated with that job are. And we'll talk about some of those tools in a bit. And then taking those risks and applying the criminal histories available out there and saying these kind of criminal offenses are of more concern, these are higher risk, these are medium risk, and these are low risk. In and of itself, I don't care about a 10-year-old shoplifting conviction for this job. However, I am concerned about a 2-year-old, assault case. So, but before you ever meet the applicant, but you already know for this job, these are the kind of things that are real concern. These are the kind of things of moderate concern, and these are the kind of things that in and of themselves are not a concern. Then you've got a good employment application that you either, whether it's an electronic application or you're still doing a paper application that somebody's filling out and turning in, it will not let an applicant leave a question blank. And that goes for termination reason for previous employment, any claims that they've made about education, getting all the details that they're claiming, whatever it is, or the criminal history inquiry. A good process where you collect all that information at the point in the process where you legally can, especially on criminal history. But then you've also got interview training. So you've got your hiring managers and your interviewers, maybe it's an HR, it's your recruiters, or maybe it's somebody on the hiring side. But they're trained to talk to applicants about their criminal history, to get additional information. If the applicant said, yeah, I did get convicted for theft 5 years ago, you get to the interview and you talk to the applicant about it and find out what happened. And I found that interviewers, even HR folks, are so scared to ask about criminal history that they often don't dig into it, even when there's a kind of a red flag out there, and then sometimes they regret it later because they didn't ask the question. Or sometimes their knee-jerk reaction is to not hire somebody because of their criminal history, because on its face it looks pretty sketchy, but then when they dig deeper into it, they find out, okay, well, this is a weird situation. And there are a lot of them out there. Because I talk to applicants almost daily now. And I spend a lot of time talking to them about how to present their criminal history to employers so that they don't have that kind of issue. But all the same, there are unique situations, and there are times where it probably makes sense for you to look beyond just what the offense description was and the fact that it was a conviction or whatever came out of the case, and dig deeper and understand from the applicant's point of view what really happened, then verify it. And that's the last thing. The last piece of your background screening process is the background check. And so when we're talking about bulletproof background screening, we'll give you a bulletproof background check. You're not going to get in trouble because of imperative background checks. We've got a whole, we're more expensive than what a lot of employers are spending right now on background checks, but we never have to say we're sorry, and that's our target. But that's just the last piece of the whole process. If you want a bulletproof background screening process, most of it's on the employer, and all we're doing at the background check is verifying that the applicant told you the truth. And if you've got a good process in place, you should have very few surprises, really. Because that employment application, that interview process, they're really just a lie detector test. They're the least expensive integrity test you will ever give this applicant. If they lie to you coming in the door, well, then it's on them if they get eliminated later on. And even if you don't do your background check until after an offer is made, you can, and you rescind that offer, it's on them. They lied. If you've had a really good criminal history inquiry, there should be no surprises. So let's jump into some of the tools that we put together, the first being the relevance matrix. Basically, as I mentioned earlier, we want a way to categorize offenses for specific jobs as low risk, medium risk, or high risk. And then we'll take action based as an employer, take action based on our policies as an employer according to the decisions that were made before we ever met the applicant. So if something's low risk, let's say it's a death by check from 5 years ago, we don't really care about that. That's low risk. It's not going to affect this person's fitness for this job. It doesn't cause us any concern in and of itself. Medium risk, well, you know what, this kind of offense is of concern, and we may want to do additional research, get more information from the applicant. We're not going to eliminate the applicant based on it, but we may want to get more information, and we may want to dig deeper into it, try and verify what they tell us, and see if it makes sense, and see if it makes us inclined to hire that person. Are they still our best candidate versus the rest of the population that we have? And then there's some things that are high risk, and you're basically the inclination with a high risk criminal history is that they're not eligible for the job. But maybe, it may make sense to dig deeper, to get additional information, find out what the applicant told you, evaluate everything the applicant's bringing to the job. Every now and then, especially with salespeople, it seems like salespeople are salespeople or people working in the oil field. That's where we get a ton of criminal history records. But salespeople, especially who are high performers, by nature, salespeople kind of cut corners. They tend to, they're the guys who, you want them to be those kind of low compliance guys sometimes who get in front of that manager, to make a sale where maybe, but sometimes that. If they were following the rules of the company, that they were selling to, they'd have to go to procurement or whatever. You want these salespeople to be, kind of clever and things. But sometimes that same cleverness is what gets them in trouble. So, but you might say, this guy's an amazing salesman. He brings in a giant book of business, but he's got this drug conviction from 2 years ago, and we're really kind of concerned about that. So you may have to say, we normally wouldn't put somebody in this position, but when we evaluate everything the applicant brings, we're going to make an exception here. We're going to document why. We're going to document what controls we're going to put in place around this particular person to make sure they don't cause a problem. So what that really looks like is something like this. Here's an excerpt from a sample relevance matrix. And let's say this is for a car lot. And you can see this guy, if say the applicant had alcohol or consumption possession cases, open container, that kind of thing. Not a DWI, just open container on a public street, things like that. You can see those are marked as low. They're green. They're low risk. In and of itself, we're not going to eliminate somebody from being a car salesman in our car lot because of that. In fact, you probably couldn't find a car salesman who didn't have some kind of issue with alcohol at some point. But then you see computer crimes, and there are all kinds of computer crimes, and they're called all these different things in different jurisdictions. But if this is, say, the last 3 years, it would be high risk. We're going to mark them as a high risk case because it's of concern to us. We want to make sure that we know, what the computer crime was. This person's going to have access to personally identifiable information in the company's networks, things like that. So we want to know what was the real computer crime, what did he do, and we'll investigate deeper and then make a decision. And then you can see if it was, say, this is 3 to 5 years and 5 to 7 years or whatever, it's a medium risk. We're still, computer crimes are high risk here, but they're medium out beyond 3 years. We'll still figure out what happened, understand the context, but it's less concerning than a more recent one with a high risk, with a computer crime with what they do. So then you get auto theft. And you know what? If you've been convicted of, say, the last 7 years of stealing cars, you're probably not the ideal candidate for my car lot. And so if you've been convicted of auto theft in the last 7 years, we're not going to hire you. It just doesn't make sense for us. And more than 7 years may make it a medium risk, and so we want to look at how long ago it was, what did the person do, was it one car or a whole fleet of cars, those kinds of things. And so that's what a relevance matrix is. So you can see when you get the employment application back or the criminal history inquiry, whenever you ask, you can immediately apply your own policies already. You already know what level of scrutiny this offense will deserve in your process. So we've got some tools that we've put together to help employers put that together, put these this criminal history matrix together. So it starts with this position risk review checklist. And basically, we look at a variety of things, what kind of access the position has, what level of supervision they work under, who do they work with, do they deal with the public, or are they in what's that work environment like, are they entering people's homes, stuff like that. Are they in a position where they automatically get a high level of credibility because of the position? They wear a uniform, or they a minister of some sort. And then what are their job responsibilities? Handling cash, operating a motor vehicle, those kinds of things. And so we go through there and say, so for this position of this class of positions, and so you don't have to do it for each and every single job, but you may say, this is for administrative clerical positions in our environment that don't handle cash or ever operate a motor vehicle. So you can go through and fill this out. So you know all your admin clerical positions, this is generally what we're going to be concerned of. These are the kind of risks that are associated with that job. Then you can take that and convert it over to this matrix that connects. These are those same things, what they have access to, their supervision level, things like that. See access and supervision level, those kinds of things. And then you see different kinds of crimes against people, financial crimes, property crimes, alcohol crimes, computer crimes, all these. And then you go through and say, okay, if somebody is, they've got access to personally identifiable information as part of their job, I'm concerned about financial crimes. There's a connection between financial crimes and having access to PII. And maybe computer crimes too. If they've got access to PII and they've been convicted of computer crimes, yeah, that's a concern for me. So you're just kind of going through here and marking not the level of concern, just that there is some concern out there. And then we take it to the matrix that we were talking about earlier. And so what that would look like is, again, you've got crimes against persons, financial crimes, property crimes, alcohol, computer crimes, things like that. And you see down over here 0 to 3 years, 3 to 7 years, or more than 7 years. And you see things are medium risk, some things are high risk, and some things are low risk. So once you've put all those together, you can say, okay, for this job, car salesman, this is generally what our policies are going to be. This is the level of scrutiny. We're not concerned. Low risk, we're not concerned. Medium risk, we're concerned. We want to get more information, make sure we understand the context of what happened. And high risk, unless there's a really good, unless there's no other better candidate or no other candidate out there, or unless this candidate is just amazing and we really have to have them, our inclination is to find a better candidate. We're generally not interested in putting somebody with this high risk criminal history into this position. And this takes time. My clients who've done this, we've worked with, they've spent hours and hours doing it for the different positions. I really suggest that HR be involved, but also your frontline supervisors or hiring managers, people who are actively involved in dealing with that job on a regular basis. And so that's, well, I'm getting some more notes here. Some people say that the sound is gone, one person said the sound disappeared, and I'm sorry for that. But we'll keep going. I'm hoping you can hear me. So this is what you end up with, and hopefully with something like this, you can have your policies documented and defensible. So let's talk about some other issues beyond the relevance matrix. What are you going to do about dismissed cases? That's it's an issue because it may depend on what state or even what city you're working in as to whether you can even consider dismissed cases. But in most jurisdictions in the country, you can consider dismissed cases. And why would you? Well, cases get dismissed for a lot of different reasons. In some cases, the person pleads guilty, and then he gets deferred adjudication. And at the end of the deferred adjudication, the case gets dismissed. And the dismissal is a dismissal. Means they weren't convicted of the offense, but they've pled guilty or no contest to it, and they serve probation for it. It's reasonable for you as the employer to believe they engaged in that conduct when they've pled guilty or no contest to it. There may be also cases where employers can look at a history and say, you know what, the case is dismissed, but they've got several cases for domestic violence, and they were all dismissed. Well, that's a red flag. and I would tell a client, okay, the cases were dismissed, but let's dig deeper. Let's find out why they were dismissed and what was in the police reports. And so we go pull even police reports sometimes, and we'll see that, yeah, it's Friday night, he's been drinking and starts hitting the wife. She calls the police to get him off of her. Police come and get him, put him in jail, but then she's down there on Sunday or Monday morning saying, I'm not going to cooperate with prosecution, I just want him out of jail. And so that happens repeatedly. That tells me, when I see that, and I've got the documentation from the police reports that say, yeah, we showed up and she had a bloody nose and he was yelling and screaming. I see that once or twice, 3 times. As an employer, I can say it's reasonable for me to believe they engaged in the underlying conduct. So I'm not hiring them because they were charged with the offense. I'm not hiring them because the underlying conduct is evident. And that's why we use criminal history, right? We're concerned about what the person did, not how good their lawyer was and whether they got a conviction or not. We're concerned about whether their underlying conduct presents a risk in this position. So I would say just because the case was dismissed, you may want more information, especially if it's a case that would have been of concern had it been a conviction. Let's dig deeper and find out what was going on. Focusing on misdemeanors and felonies is, in my opinion, a mistake. What's a felony in Texas can be a misdemeanor in Oklahoma. In fact, we saw a case recently where a statutory rape was a misdemeanor in Louisiana, where it'd be a felony here in Texas. And again, if you're really focused on the underlying conduct, do you care that the person stole $3,000 or $15,000? The fact is, if it happened a year ago, they stole. Okay, they committed theft, and so does the amount matter as much as what does that conduct tell you about them? So we tell our clients to write their policies not around misdemeanors and felonies, but about what the conduct was. Let's look at that. And beyond that, I do want to remind you again that there are some states that limit how you can consider certain kinds of offenses. In San Francisco, as crazy as it sounds, you can't consider infractions when making a hiring decision. Those are, minor ticket-only kind of offenses, which is fine, except what if you're hiring somebody who's a driver? And maybe it's just somebody who makes pizza deliveries for you, or is going to be running to the bank every day for you, or whatever. You can't look at their driving history to get their ticket history to know how good a driver they are. So you need to know that state by state there are some, and even city by city there are some limitations on that. But generally, be focused more on the underlying conduct than what the case is categorized as. Let's do one last poll. How do you treat pending cases? If you see your applicant has a pending case, what do you do with that? And if you don't know how you deal with it, just mark it as other. But okay, I'm going to close it if I can get just a couple more people. Okay, good. Share those results. So about 20% of you said you don't consider them at all. A quarter of you asked them just to reapply after they've taken care of their business, and that's not a bad idea. That's not I hear that a lot. 3% said that while the case is pending, you consider them as convictions, which is kind of the same as telling them to reapply later. The reason I like considering them as convictions, because if somebody's got a pending case, that won't send them to jail for a period of time, so they're not going to be unavailable for work. You may not consider, if it's a hot check case, and you find out, yeah, it's a hot check, and they wrote a check to the grocery store for $45 and it bounced, and they never took care of it, and so now the case has been filed against them. That may not eliminate them from a lot of jobs in your environment, and so you might say, yeah, we don't, if it's a conviction, even if it were a conviction, we wouldn't care about it, so I'm going to go ahead and make the offer to the candidate. Whereas, and if it was something that was a conviction, you would basically tell them, well, after the case is resolved, you can reapply later. And then 20% of you said it depends on the hiring manager or the job and what they want to do. I'm less crazy about that one because I really think you ought to look at pending cases like you do everything else with a policy in advance. It's not really specific to the what the hiring manager wants to do. So, but there you go. Those are some issues. And do ask any questions. I'll try to find them around all the messages I got that sound wasn't working, but I'll hide that and we'll get on here. So again, my recommendation is that you go ahead and treat pending cases just as though the person engaged in that conduct. That doesn't mean you're putting a scarlet letter on them forever. But what you're saying is, if it's something that would have been of concern and maybe eliminated them from consideration, go ahead and look at it now. Then they can always reapply later. But you may hire more people and not exclude people to fill a position right now. If it's a pending case for something you don't care about, then go ahead and just, if you treat it just like like it had been a conviction, you're willing to hire them, go ahead and do that. What about wanted? If they've got warrants for their arrest, well, that's my recommendation, no matter what the warrant is for, is that they're not eligible for hire until after that warrant's been lifted. And so tell them to go take care of their business. I don't care if it's a warrant for a traffic ticket or whatever. You want them to be available for work. And so you don't want them driving to work and getting pulled over for speeding or whatever, and the next thing you know, they're going to jail and not available. So they need to take care of their business before they come to work. That's the advice we always give our clients. What about cases that are conspiracy to commit, fraud or attempted theft or attempted murder or whatever? Just because they weren't good at it, they're not a very good criminal, doesn't mean that they're any more hireable. In fact, if they're not even competent enough to commit the criminal offense, do you really want them as an employee? But the reality is, if we're focused on underlying conduct, the underlying conduct was an intent to do this. They attempted to do it. So we always tell our clients, whatever, if it's a conspiracy to or attempted offense, go ahead and just treat it as the same outcome as the intended offense. The underlying conduct is what we're concerned about. What about repeat offenders? Now here's where we really jump off and struggle with employers documenting what the policy is going to be. Remember Otis on Andy Griffith? He was in very unpolitically correct terms, he was the town drunk. But he was in and out of jail all the time. Otis would not be a good employee, right? So maybe public intoxication isn't something that would eliminate somebody from employment. But if you see 3, 4, 5 of those in the recent years, what does it tell you about this person's lifestyle and their reliability as an employee? Or you just see, like we talked about earlier, a theft by check, a failure to appear, an open container, just a whole bunch of little piddly things. Well, you know what? That's non-compliant behavior. And this guy is telling you, I'm going to be somebody who's a lot harder to manage. Now, if their little mini crime spree was 20 years ago, you probably don't care. If they've lived the last 15 years clean and free, or the last 10 years clean and free and haven't had a whole bunch of petty issues, then you probably don't have an issue. But if you see something recent and they're consistently being a knucklehead, well, then let them go do that on somebody else's payroll, because they've already self-identified to you that they're going to require more management attention. And thank heavens I'm in Texas, but some states and municipal ordinances have their own regulations on what you can consider. And so you really need to be working with your legal counsel and your background screening firm to identify those on a city-by-city basis. And it's getting crazy about when you can ask criminal history or even what you can consider. Now, New York City has a policy in place that you have to, if you use criminal history and decide not to hire somebody because of it, you have to give a written explanation of how you evaluate, using 8 different factors, how you used 8 different factors to evaluate that criminal history and against the job to determine whether the person was eligible for hire or not. So that's kind of ridiculous, but that's the law in New York City. So we're working with our clients up there to get it done right. So just make sure you pay attention to those details, because you're ultimately, you're going to want to make sure that as this explodes and we continue to create this protected class called criminal offenders, you're going to need to, as an employer, make sure you get all your ducks in a row. But the bottom line is look beyond exclusions. Let's look at the entire applicant, everything they bring to the job, and look at what they, look at their pattern and behavior and see what it tells you about the kind of employee they're going to be. So we'll go to questions now. I appreciate everybody hanging with us with all these technical issues. If you're not the victim, how would you get a copy of the police report to show a person has a pattern of behavior in making a hiring decision? Well, it's going to depend on the jurisdiction. In many jurisdictions, we can get police reports. They're available under public records. In some places, they're not. California is an example of a place where you can't easily get a police report. But if a case has been filed, often there's an offense description in the police report that would describe what happened, what the underlying conduct was alleged to have been, and you get an idea from that. Comes down to it, the person about whom the report is made always has the ability to get a copy of it, and you can always get them to sign an authorization to provide it and get it that way. And we've had to do that on occasion. Are there any other questions about any of this? I only have one question. Okay, after a warrant has been issued, how long does it take to show on a report? Okay, well, that's going to depend on the circumstances surrounding the warrant. If a case has been filed against somebody at the county level, typically, the case will show that there's an active case and that a warrant has been issued for the person. So that's how, so it would be immediate if it shows up, if it is, on a case that's been filed. If there's a warrant for their arrest, but there hasn't been a criminal case filed, you probably wouldn't see it in most cases. So that's kind of how that's going to play out. Any other questions? You guys have borne with me. Is there a way to find out if a current employee has been arrested while employed? We only do checks at the time of hire. Okay, well, yeah, there is, and I would really suggest you revisit that policy. Probably about half of our clients do either annual or biannual background checks on all their current employees. And those are typically smaller criminal background checks that may include a driving record, record of a criminal record search in a county where the person lives and maybe where the company is located if they're in 2 different counties, things like that. And so it's a smaller scale background check, but it's kind of an update to see, make sure nothing's coming up on, about them that you don't know about. And you always think, well, we would hear about it, but I've got a client right now, we're just finishing up their annual background checks. They've got 450 employees roughly. And they're going to find out as when we make these reports to them that a few of the people have been in trouble. That doesn't mean they're going to eliminate them, but from it, they're going to terminate them, but they might, because they have a policy that says if you have any police interaction, then you have to notify the employer within within the next business day. So if you get arrested or you get a case filed against you or it becomes the subject of some sort of criminal investigation, you should have to tell your employer. And so if you've got that kind of policy, then how are you going to verify it? Well, you're going to do some sort of background check on an ongoing basis. Now, under the Fair Credit Reporting Act, depending on what state you're in, you may have to get a fresh authorization from the applicant, depending on how your original authorization was written. So if it says that they can do it, the employer can pull your consumer report, the background check, at any time with regard to their employment, then you're okay, except I think Connecticut requires a new form every time. So that's kind of how that works. Any other questions? If not, we will close the webinar. But if you have questions, feel free to email me as well. Shoot me an email, give me a telephone call, whatever. I'll be glad to help you if I can. A number of you on the call are my clients, and I appreciate y'all being here. And finally, I'll just close and say, if you aren't our client and you don't feel like you're getting what you need from your background screening partner, we would love to talk to you and talk to you about working with you. the same level of attention to all the details that we hopefully encouraged you to take during your processes today. That's the same level of attention we give to everything we do for our clients. And like I say, I'm an HR guy, and we're the background screening company started by an HR guy because we wanted to get it right. And so if I can be of service to you, please don't hesitate to give me a call. In the meantime, you should expect a email from us later this afternoon with a link to download all the notes from the presentation, as well as a link to the video and the HRCI and SHRM professional development credit numbers, so that you can get all of that. We'll ask you, in exchange for those numbers, we'll ask you to do a quick survey and just tell me how I did. You feel free to mention the technology stuff. That's great. But just give me some feedback on that, and I appreciate it. And at the end of the survey, you would get your information. So watch for that email. If you don't get it today, shoot me an email tomorrow. Check your spam filter. But if it's not there, shoot me an email, and we'll get it to you. Thanks a lot. We hope to talk to you soon. See you at the next webinar. Thanks.